Good afternoon, everyone. We are here with attorney Ruby Powers. She's a certified immigration and nationality attorney, and today we're going to talk about the O-1 visa, or the Extraordinary Ability or Achievement visa. We are here also with Powers Law Group, the law firm. Thank you, Ruby, for being here today.
Thanks so much, Ileana. So we wanted to talk about the O-1. It's not really well known necessarily. Maybe some people spread the word, but it is a great opportunity. There's no limit to the amount of O-1s that are provided, like some other visas have limits and caps, but there isn't one for this. Um, it's a non-immigrant visa, but it has a lot of potential and can be given for the maximum of 3 years. So let's go ahead and go into a little bit of an overview of the eligibility process and periods of stay. So the O-1 is for an individual who possesses extraordinary ability. So it's really easy to sort of remember, like outstanding, O for outstanding, if you will. And so it could be for science, arts, education, business, or athletics, or who's demonstrated a record of extraordinary achievement in the motion picture or television industry and has been recognized nationally or internationally for those achievements. So there's different types of O's, and so we'll go in through them one by one. The O-1A is for those with extraordinary ability in the science, education, business, or athletics. And that's not including arts, motion pictures, or television. We got another version of the O for that. So the O-1A, for example, would be Olympic gold medal award winner, national level scientific award, membership in an organization with very high standards to be a member, article written by you or about you in a major publication, acted as a judge or evaluated work for others in your field, so you're high amongst your peers in a small subsection in the world within that space. Significant accomplishment in the fields of science, scholarship, or business, and employment as a key figure in a major business organization or a very high salary in less critical position. But the more you have, the more that apply, the better. And it's a great opportunity to be able to come to the United States and to work and come here for a short period of time. It is a non-immigrant visa, but some people later switch to an EB-1 visa, green card possibility later on. So the O-1B is more for the motion picture or television industry. So a star or leading role in a major production or event, national recognition from important critics, critical role in a reputable organization connected to the applicant's field, reputation for significant success, significant written recognition from other experts in the field, significant salary, other financial success. And so these are other examples. Now, O2s are those who are going to accompany the O-1 artist or athlete. So this could be, that's usually like agents, assistants, and so on that need to be there to be part of the team to assist in a specific event or performance. And O3 are the spouse and children of the O1s and O2s. So this does consider all the possibilities of those who would need to accompany the O-1. Now, what are the requirements or eligibility? The O-1, you must demonstrate the extraordinary ability by or sustained national or international acclaim or record of extraordinary achievement in the motion picture or television industry, and must be coming temporarily to the U.S. to continue work in that area. So this works great if it's like for some meetings, conference, filming, performances, those types of things. Extraordinarily in the field of science, education, business, or athletics means a level of expertise indicating that you're one of a small percentage who've risen to the very top of the field. And you usually show that by your news, your written, the awards, your membership, basically by establishing your credibility in the various ways in your career space is how you would show that. And to qualify to be an O2, your assistance would be an integral part of the O1's performance, or you must have the critical skills or experience with O1 that are of not a general nature. It cannot be readily performed by a U.S. worker. So it really has to explain why you need that individual to come accompany you, and it couldn't be replaced by somebody already in the U.S. If it was of a general nature. That's something that you'd have to establish with their own resume, job description, and what's the purpose of the O2 following the O1 to the United States for this process. So the application process would be a U.S. employer, agent, foreign employer through a U.S. agent would file the form I-129 on your behalf. This form I-129 is used for many non-immigrant visa opportunities here in the United States, along with the required evidence like we've already talked about. The employer agent would file the I-129 at least 45 days before the date of employment, and the petitioner must provide a written advisory opinion from a peer group or a person with expertise in the beneficiary's area of ability. If the petition is for an individual with extraordinary achievement, motion, picture, or television, the consultation must come from appropriate labor union and or management organization with expertise in that beneficiary's area of ability. And a contract will be needed between the petitioner and the beneficiary. The petitioner must submit a copy of the written contract between you and the petitioner, or a summary of the terms of the oral agreement that were under which you'd be employed. So then you need to demonstrate the itineraries of what your planned activities would be, the nature of those events, with ideally with beginning and end dates, copy of the itinerary for the events and activities. The petitioner must establish that there are events or activities in the field of extraordinary ability for the validity period requested. So, for example, if you ask for 3 years, but you only show 1 year worth of itinerary, then that wouldn't make sense for them to issue you 3 years. So it would need to be consistent with what you're asking. Agents, a U.S. agent must be your actual employer, the representative of both you and the employer, or a person or an entity authorized by the employer to act for in the place of the employer as its agent. And evidence demonstrating that O-1 eligibility that we talked about. That petitioner must provide evidence demonstrating that in the science, arts, business, education, or athletics, or extraordinary achievement in the motion picture industry. The record must include at least 3 different types of documentation corresponding to those listed in the regulations. So the more you have, the better, and the easier it will be to demonstrate that you meet the requirements. So it could be allowed up to 3 years, and you could do an extension if you can verify why you need that extension, but it'd be in 1 year increments. And when you come in as an O-1, you may be admitted for the validity period of the petition plus a period of up to 10 days before begins and 10 days after. And that gives you that transition time. And you're only allowed authorized work during the validity period of the petition. So you have to be cognizant of that, knowing when those dates are, and not working any longer without authorized stay and work authorization. So the extension, if you need one, can happen if you have to complete the form I-129, a copy of your I-94, which shows how long your stay is authorized for, and a statement explaining the reason for that extension that's needed. And so you would want to submit that as early as you can if you know that is going to be needed, so that you are not delayed and you don't have any unauthorized work authorization time. So this is a really great opportunity for individuals, and it can be a pathway to legal permanent residency potentially, even though it is a non-immigrant visa, but it also could be an opportunity to come to the United States, do work in that space and create relationships and continue to build your resume and have other opportunities that might arise from that. So it is a great opportunity and can be used for a lot of different facets. And it's something that I think a lot of times people overlook, but it could be used in so many different spaces, from business to science to arts and theater. And so I think that's it for today. We're going to go ahead and do this presentation in Spanish later. But Eliana, how can people stay in touch with us?
So here we have all the social media platforms where you can find Powers Law Group. You also have the number, so if you want to make a call or have a consultation or ask about anything, you can reach out to us through the phone, and all the social media platforms. We also share daily updates and all the things that has to do with immigration.
And then we also have the rest of this month's recordings, our video webinars we're going to have. So
yeah, we already did the what is the F1 visa, student visa. Today we did the O-1 visa, and we have already left for victims of criminal activity applying for a U visa, and we also have the I-601 an unlawful presence waiver.
yeah, I-601A, that's right. And it'll be 10 years old in March 2023. Can't believe that. But we have lots of clients that are benefiting from that program. So continue to watch us Wednesdays in English and Fridays in Spanish on these topics and generally. And thanks so much for watching. Feel free to share with a friend this video if you think that they could benefit from it, and continue to monitor our social media for updates in immigration.
Thank you so much.